Good afternoon, ladies and gentlemen. Thank you for that kind introduction. I appreciate it. It's a pleasure to be back at the Elderwerks Expo. And as you know, my name is Kerry Peckett. We're going to talk today about state planning needs for the future. I'd like to do these in a very interactive fashion. If you have a question, let me know. It's more logical to discuss your question at the time we have the slide up there rather than waiting until the end. So we're going to take it away. Maybe. No. We did a trial run and it worked perfect. All right, informal survey. How many people have estate plans? Okay. How many people in their estate plans have revocable living trusts? Few. And how many have powers of attorney for healthcare? Powers of attorney for property? Okay, now here's a tough one. When's the last time you looked at your estate plan? A month ago? Couple months. Years. Okay. Years. How many people haven't looked at it in 3 years? Okay. Those are the people we're talking to today. Okay. Thank you for that, Chris. All right, so we're going to discuss what estate planning is. We're going to discuss strategies. We're going to discuss documents, modern planning considerations, and we're going to discuss probate and the related estate complications. So the unthinkable happens. This is for the folks who haven't looked at it in 3 years. We thought we had more time to plan. My husband was diagnosed with early onset of dementia. Can we get our estate plan done now very quickly? We get these kind of calls virtually every day. Unfortunately, I think Alzheimer's disease, dementia of a variety of different types seems to be growing, but it's logical because there's more people getting old and there's more regrettably bad diagnoses. So don't wait until a loved one is diagnosed. Do it now. So this is kind of an interesting statistic. 1 out of 4 Americans without a will never plan on getting one. And more than 40% say they'd wait until the medical diagnosis, which perhaps we just talked about, could be worse, or worse than an early onset, might be stage 4 cancer. So we're going to look at, what's estate planning. Estate planning, in large measure, most people focus, I think, upon the distribution of assets when you're dead. But a lot of estate planning documents relate to when you're alive. Certainly, power of attorney for healthcare, power of attorney for property, and revocable living trusts are documents that have viability and we use during our lifetime. A will has no validity during your lifetime. And a power of attorney, both types, healthcare and property, they die when you die. So we've got a number of documents that have considerable importance while we're above the ground, and particularly one that has greater importance when we're below the ground. So even before estate tax, the goal of tax planning is to protect assets from creditors, preserve family wealth for future generations, provide for support and income to the family under all circumstances, and manage assets for those who cannot manage themselves, and a business succession plan. Those of you that are still working and have businesses, it's important to plan for succession. So what can I expect when I do an estate plan? A small estate plan will manage your assets during your lifetime for your benefit, particularly if you become unable to manage them yourselves. Circumstances, you have a stroke. The question is, can you still manage your affairs? Let's assume for our hypothetical, you cannot. The question is, what arrangements have you made in writing to manage your estate if you're no longer able to manage it for yourself? And concurrently, do I have the mental capacity to do new documents? Depends on the circumstance, depends on the stroke, depends on the diagnosis for Alzheimer's disease, depends what stage the Alzheimer's disease is. Similarly, for cancer, might affect your cognitive abilities. We know it's going to affect your physical abilities. So under what circumstances would it make sense to distribute assets during your lifetime? Most people provide their distributions post-death, and they leave it to their closest family. Some people leave it to charities, some people leave it to the schools they went to, things of that nature. So how and by whom is your personal health care decisions going to be made if, again, you're cognitively impaired and unable to make those decisions? You need to choose those decision makers while you're capable of making that decision. How and to whom your assets are going to be distributed, I just talked about it. And who will be the guardian if you have minor children when you're unavailable? Circumstances may be that you're taking care of your grandchildren. Maybe somebody passed away. Yes?
Does that include like disabled children? There's a lot of older adults who are taking care of their adult disabled children and they pass, and then there's no one to take care of their disabled.
Okay, so I don't know if everybody heard your question. Question is, does that include adults taking care of their own disabled children? Who's going to take care of them when they pass? And of course, the direct answer is we want to create special needs trusts for those disabled children. Sometimes it's called supplemental needs trust. The concept there is that child will continue to receive government benefits while there is a trust set aside that's excluded, doesn't disqualify them from government benefits. And you would typically name a loved one or a corporation, a bank, to manage those assets for your disabled child. So a large estate may focus on tax planning, particularly the Illinois inheritance tax. Illinois has an inheritance tax. If you have an estate in excess of $4 million, you will pay Illinois an inheritance tax. And it's a substantial tax, and it's collected by the Attorney General. Through the use of revocable living trusts and the like, we can reduce or totally avoid that tax. So I've already said it multiple times. You're going to hear me say it probably another 20 times during this presentation. You must have the mental capacity to engage in estate planning. And that mental capacity is a continuum. It's not from one end to the other. It's kind of a continuum. And typically we lawyers talk about it in the context of the phraseology, testamentary capacity. And if you don't have testamentary capacity and you still do documents, those documents are subject to challenge when you die, or even during your lifetime, if we're talking about, for example, power of attorney documents. We have a lot of cases in which, regrettably, agents under power of attorney, typically a loved one, steals the assets from their relative. And the question is, did they have testamentary capacity or contractual capacity to sign those documents when they did? So this is really a repeat of what I just said: testamentary capacity, contractual capacity. And the question is, do you have some form of diminished capacity? Again, go all the way back to one of the opening slides My husband has been diagnosed with Alzheimer's disease. The doctor says it's early onset. If it's early onset Alzheimer's disease, you probably do have the capacity to do an estate plan, but you don't if it's stage 4 Alzheimer's disease and you're not capable of executing documents of this nature. So in my office, we're constantly being asked to assess an individual's capacity to do estate planning. And for the most part, we're relying on that individual's treating physician. And literally, doctor, does Carrie have the capacity to do these documents? And doctor, we want a note or a report from you to put in our file that says they have the capacity and perhaps can be used at a later date to defeat a challenge to those documents. We see a lot of cases where one child takes dad who has Alzheimer's disease to a lawyer, rewrites the will, rewrites the trust, rewrites all the documents, and cutouts his or her siblings. You know, the brother, sister, gone. You're cut out, everything's left to me. And dad had Alzheimer's disease when he did it. So those are particularly the kinds of documents that are subject to challenge. So in a common estate plan scenario, typically we would use a last will and testament. Now, I mentioned earlier, a will has no validity until you die, okay? A revocable living trust, which today is a very common estate planning device, has validity during your lifetime. In a revocable living trust, I name myself, Carrie, as trustee initially. And when I become incapacitated during my lifetime, or I die, I have in the same document named a successor trustee, okay? That successor trustee is going to take over again if I have a stroke, if I have Alzheimer's disease and can't manage my affairs, and when I die. Why do we use a revocable living trust? Because it can be used during your lifetime and upon your demise. And it's a seamless scenario, provided what we do is we ask our clients to fund their trust and basically put all of their assets into the revocable living trust. If it's a husband and wife, literally they divide their assets, half goes in husband, half goes in wife. And the title of the document is, you know, the Carrie Peck Revocable Living Trust, dated August 11th, 2025. Okay? We also, our estate plans have powers of attorney. Two kinds, I mentioned earlier, two types. Power of attorney for health care. Obviously, from its name, you can tell what it is. We name what's called an agent to make decisions for us. That agent is usually one of your children or your spouse or a close relative or a close friend to manage your health care and make decisions for you when you're not capable of making your own decisions. Now, power of attorney for health care is critically important these days because everybody in the room has heard of HIPAA, okay? HIPAA, you can't get information unless you have a HIPAA waiver. Well, the agent under power of attorney for healthcare can get the medical information, can get the records, can sit down with the doctor, can make an informed decision as to whether you should have surgery, you should not have surgery, where you should live, assisted living facility, things of that nature. We also have what's called a power of attorney for property. Both of these documents are what we call durable powers of attorney. And the term durable means they continue in effect when we're no longer cognitively able to make decisions for ourselves. So these are critical documents. A power of attorney for property is a generic term. It doesn't relate exclusively to real estate. It relates to all of your property, your personal property, and your real property, your real estate. Again, critically important, potentially, you need to sell a piece of real estate to pay for going into a long-term care facility. Your agent under power of attorney for property has the authority to do that. Transfer on death instrument, typically lawyers use the acronym TODI, T-O-D-I, transfer on death instrument, and it means what it says. It's used exclusively for real estate, and upon your death, it's immediate transfer. It avoids a post-death probate. In Illinois, if you die with assets in your name alone, saying it again, in your name alone, in excess of $100,000, the law requires we open a post-death probate. Post-death probate is a court proceeding opened in the county that you live in or died in, and that is in the circuit court of whether it's Cook, Kane, McHenry, Lake, Will, etc., DuPage. The circuit court of those counties all have probate courts. And a post-death probate is opened in those courts, and the court administers your estate. The court will appoint an executor under your will, if you name one, or if you die without a will, the court will appoint what's called an administrator, and you will have died, again, another fancy legal term, intestate. Intestate means you die without a will. The last item on this slide, joint tenancy, very commonly used between spouses or between parent and children. A and B own an asset. It can be real estate. It can be a checking account. A dies, it goes to B. It avoids probate, regardless of its value. Don't forget, I said $100,000 in your name alone. Questions? Okay. Yes.
How common are the trusts? Are you doing this more and more?
Could you speak up, please?
Who needs a trust and how common are they?
Trusts today, revocable living trusts, are very common. And I think that, some people want to know if there's a dollar figure. I don't necessarily think it's a dollar figure because you're able, again, it has lifetime validity. When you're no longer capable, you can name a trustee to take over. You put your assets into trust, you avoid probate. Okay, so it's primarily a probate avoidance and a lifetime and post-death validity scenario. If you don't put it into trust and it's in your name alone and it's in excess of $100,000, you're going to probate court post-death. All the way and back. We need to hear your loud voice.
Probate court. You have a home that is worth more than $100,000, and you're the only person who wants to leave. That probate.
You're going to probate. Everybody hear the question? Sorry?
Even if you have a spouse, if you're married.
You're married and it's not on the deed, it doesn't say husband and wife, Mary and John, you're going to probate. Okay?
Thank you.
Sure. Yes, ma'am.
Is there a cost to the living trust? Is it expensive to do that?
It's not necessarily expensive. For example, in my office, we do offer free initial consultation, which we can do in person, we can do by Zoom, we can do by telephone. We have offices in Oak Brook, Northbrook, Lake Forest, and downtown. And when we know what we're doing for you, then we code fees. And it's part generally of an entire package of planning, which typical planning, revocable living trust, a will, power of attorney for healthcare, power of attorney for property. There may be some other documentation, but that's the scenario.
So there is an initial cost to do that, but is there like a maintenance cost? Once you have a trust that you have to pay?
No, the question is there a maintenance cost for revocable living trust? The answer is no, unless you name a bank to be a trustee. Okay, you name a corporate trustee or a bank, then they will charge you a maintenance cost. If you name a loved one, an individual, there will be no maintenance costs, and the lawyers don't charge maintenance costs either way. Yes, ma'am.
So if you put your house in your trust, how does that affect your taxes if it's owned by the trust?
It doesn't affect the
Okay.
taxes. It's fine.
How much is a bank charge to be?
Bank charges a percentage generally of the assets.
All the assets.
Right.
Okay.
Yeah, and each bank has its own fee structure. You can call the bank, they'll send you a fee schedule.
Okay.
Now, if you don't have a loved one and you know, or you don't trust your family, you know, and I'm sorry to say that to you, but you know, you heard the introduction. I was hired by the city to rewrite the State of Illinois Elder Abuse and Neglect Act. I'm working now as chairman of the Supreme Court Commission on Elder Law, and we're constantly looking for changes in the law to make sure older adults are not financially exploited. Now, they are financially exploited by strangers, but regrettably, they are very often exploited by their family. So if you don't have family that you trust to do it, a bank's a good choice. It'll cost some money, but the money will be there for you. No. So your house or your bank account or your stock account, they're on it as beneficiaries or they're on it as joint tenants?
That's my question. So would you put them on it?
There is no ramifications to them during your lifetime. Okay, obviously, once they inherit, they're gonna pay income tax on the earnings on that stock account or you know, checking account if it earns interest. But not during your lifetime. Okay, let's move on. We got a lot to cover. Let's see. So last will and testament, operative only upon death. You appoint an executor under a will. Again, a loved one, a bank, a corporate executor. And in large measure, it directs payments of debts, last expenses. And again, most people focus on who's going to get the money, who's going to get the property. That's what your kids are concerned about. That's what your loved ones are concerned about. Who gets the dough? Okay, it's that simple. A public document, it is required to be filed within 30 days of your death in the circuit court of which you die. Now, this is a very important document, and I'm about to say a very important concept. Your original will is a critical document. You must know where it is. You must keep it in a safe place. And you must tell your relatives where it is. Because in Illinois, if your original will cannot be located, and I'm talking about the document that bears your ink signature, and it needs to be signed in the presence of two disinterested witnesses and a notary. Again, if your original cannot be found, it will be presumed that you died without a will. Okay? Not a copy, not a Xerox, not an electronic PDF, your original will with a signature, your ink signature. Now, I'm working as chair of the commission to try and create what we're going to call a will depository, where people during their lifetime can put it with perhaps the clerk of the court or put it with another government agency, so they never have to worry about the inability of finding their will. But until that happens, please, I can't tell you how often people do wills and their family never knows where it is, and they come in with a copy and they say, "Oh, Carrie, we found a copy. It's great." And I say, "Sorry, the law doesn't allow the admission of that will to probate. Doesn't allow us to rely on your nomination of the executor, your loved one, under a copy. The court will make those decisions, and you will be deemed, if you don't have a revocable living trust, if all you have is a will as a dispositive instrument, you will deem to be having died, again, I used the term earlier, intestate. What does that mean in English? It means the money goes to your closest relatives. And you may not want the money to go to your closest relatives, okay? Money, and if you have a spouse and children, most people want all of their assets to go to their spouse. Well, that's not what'll happen. A percentage will go to their spouse and a percentage will go to each child. So again, we're back to the concept, original will, critically important. Know where it is and tell somebody else because you're not going to be able to tell it. So we talked about it earlier, revocable living trust. Revocable living trust often takes the place of a will. You still need a will. We lawyers call it a pour over will. What does that mean? It pours over into your trust if it's not put in your trust. Again, we want your assets in your trust. We change the title to those assets. Why? We're avoiding that post-death probate proceeding, a court proceeding. Court proceeding costs money to file to the clerk, costs money to administer to the lawyers, and you can avoid it with the use of a revocable living trust. So this document is private. We can amend it at any time as long as you have the cognitive ability to do so. It avoids the need for guardianship. Guardianship is a lifetime probate. What does a guardianship mean? It means, Carrie, can you manage your affairs? And if you can't during your lifetime, you don't have a trust and you don't have powers of attorney, we need to go to court to ask the judge in a lifetime probate proceeding to appoint a guardian to manage your assets and manage your health care. Okay, down in Cook County, we've got a half a dozen judges that hear lifetime probate and a half a dozen judges roughly that hear post-death probate. We've got one judge that hears minor guardianships, but below the age of 18, things of that nature. So in many of the outlying counties, one probate judge hears all these types of cases. So it's a question of volume. We can do estate tax planning. We can't really do asset protection for the person creating the trust. We can provide a mechanism to manage those assets for our beneficiaries. If we have minor children or we want to leave money to our minor grandchildren, we can create a trust within that trust, or a disabled child, we can create a trust within that trust to manage the assets for that disabled child, that minor grandchild, that minor child, or an adult who may be disabled and needs the money managed for his or her benefit. We can provide creditor protection for our beneficiaries, not for the person that creates the trust. And as I mentioned, it's an integral part of the estate plan. Now, irrevocable trusts are far less common. They're considerably more complex, and they're used for the purposes that are mentioned up there. So, power of attorney. There are some people in the room today who remember the ads for the Doublemint twins. Okay, how many people remember the Doublemint twins? Okay, good. I did a program yesterday. Nobody in the room knew who it was. They were all considerably younger. So, in the Doublemint twins commercial, they obviously look the same. You can't tell one from the other, really. And the use of a power of attorney, I've already said this. We're going to say it on purpose again. You name an agent. So in our hypothetical, one twin names the other to make decisions in a power of attorney. In essence, your legal clone. So, power of attorney for property, I already told you, real estate, personal property. We're going to name an agent, and with the use of a power of attorney for property and a power of attorney for healthcare, we can avoid that lifetime probate, that lifetime guardianship case. Does Carrie have the ability during his lifetime to make his own decisions? It's helpful for those assets that can't be owned in joint tenancy, your IRAs, your retirement accounts, things of that nature. And it allows your agent to pay your taxes, do your tax return, change titles, sell your property. You can see it's a very powerful document. So choose your agents wisely, because this is a scenario particularly sell property, change title, your agent can sell the property, take the money. Your agent can change their title and put themselves on it. Okay? Choose your agents wisely. Power of attorney for healthcare. Okay? I told you it comes in two different kinds. Power of attorney for healthcare, the title tells you what it is. When you can't make your own healthcare decisions, your agent is going to make them for you. Again, where you live, what kind of surgery, who your doctors are going to be, things of that nature. Again, critically important, but focusing on healthcare. And again, I mentioned critically important. You can get information without worrying about the HIPAA laws. Everybody goes to the hospital, goes to the doctor, and they walk around, HIPAA, you know, we can't talk to you, we can talk to you, etc. So, this is, you know, select trustworthy agents. Your closest relatives may turn out to be an abuser. How long have you known them? What circumstances have they been through? And is there any bone in their body that indicates that you can't trust them? If you can't trust them and you're concerned and you have questions, choose somebody else. I can't tell you how many cases were in court on literally daily in which relatives steal money from their other relatives. And as I mentioned earlier, obviously, strangers steal money. Biggest scam today is a romance scam. Romance scam in which somebody online promises a man or a woman they're going to be their lover forever. They're coming to town, send me airfare. Oh, I couldn't get that ticket. My car broke down. I'll drive in. Send me money for a car. Oh, I need a place to stay. Maybe I can stay with you. But if you don't have enough room, I need money for a hotel. Oh, I want to buy you a ring to demonstrate my love for you, even though I've never met you. Can I borrow the money? I'll pay you back. Okay. Now, everybody's laughing, but there are billions dollars, billions with a B, stolen with these romance scams every single year. So, powers of attorney, we might want to limit the powers we give to that agent. We might want to limit their ability to change the estate plan. We might want to limit their ability to sell my home. We might want to prohibit them from selling real estate. And we certainly want to prohibit them from changing the beneficiaries of the plan that we've done. Okay, again, powers of attorney documents, very, very powerful, but critically important to stay out of court. Under the Healthcare Surrogate Act, what's the Healthcare Surrogate Act? You don't have documents, okay? In this one, you don't have a power of attorney for healthcare. So starting all the way on your left, if there's a guardian, again, that court-appointed guardian, going to make decisions for you if you're not capable of making your own. Then you can see as we move across, the spouse is next, an adult child, daughter, or son, and then it goes up, unlikely the parents are alive, and all the way across. Again, this is if you don't have a power of attorney for healthcare. A surrogate will make those decisions. So when you're in the emergency room, and literally these days, after they ask you what hurts, they're going to ask you, they might start with, do you have a power of attorney for healthcare? No, I don't. Are you married? Well, yes, I am. Okay, get your spouse in here. They're probably in the room anyway. They're now in charge of making those decisions. Perhaps if you can't make those decisions for yourself. We talked about a TODI, T-O-D-I, transfer on death. It's really real estate, residential real estate, not too often used today. It used to be more popular. Tell me when you're done with your pick so I can change slides. Okay. Joint tenancy assets. I think everybody knows, but we've talked about it. We're going to talk about it again. Husband and wife in joint tenancy, typically for homes, typically for bank accounts, typically for stock accounts. Husband dies, the assets pass to the wife outside of probate, regardless of value. Remember I said that value of 100,000 in your name alone requires a post-death probate. Joint tenancy, there's no limit in value. A and B own it, husband and wife, A dies, it goes to B outside of probate. So this is something that I think most people don't know. And that is A and B own their house or own a stock account in joint tenancy. B has complete withdrawal rights to take that money out of the stock account, to take that money out of the checking account. If it's a sale of a house, it's not likely to happen. But if it's a stock account or if it's a bank account, 100% ability to withdraw. So if A goes in the hospital and B says, aha, now's the time to steal the money, B has the ability to do that. So much like I said earlier, choose trustworthy agents, choose a trustworthy joint tenant. So modern planning considerations, single parents, stepchildren, adoption, non-married couples, more and more couples don't get married after typically the first spouse passes away, and same-sex couples. Important to know if you're involved in a second marriage, okay, you need to specifically provide, if you wish, for the children of your first marriage. Because if you don't have a will, the assets might go to your second spouse, okay? You don't necessarily maybe want that to happen, maybe don't want that to happen. And if there are stepchildren in the picture, you need somebody that knows how to deal with where your assets are going. So single parents, I don't think we need to go into great detail, but if you're single and you have children, it's critically important that you provide for your children in the manner you intend. Stepchildren, I've already talked about it. I got a call yesterday, dad died. The stepmother changed the estate plan. She cut the kids out from the first marriage, okay? She put her kids in and cut everybody else out. So these are common problems in multiple marriage scenarios. Obviously, adopted children will inherit, but it's important that you provide for them. The adopted child will not legally inherit by the laws of intestacy from the parent who gave up that child. They can specifically receive money under a will, but they can't receive money under a scenario without a will. Cohabitation, non-married, the estate plan is important because under Illinois law, if you're not married and you're living with somebody and you die without a will, that person's likely to get nothing. The property is going to go to your closest blood relatives, whether you like them, whether you talk to them, or whether you hate them. So it's really important, if you're involved in a relationship, you want to provide for each other and you're not married, that you have an estate plan done. Okay, same issue, thank you. All right. Same-sex couples, same kind of scenario. If you're married, you're fine. If you're not married, then you have to deal with it in a manner of providing for them to receive in the estate plan. So this is where it gets scary. Probate court, forum for post-death issues. Most estates are going to go smoothly, but what is probate? We talked about it. There's a lifetime probate guardianship, post-death probate for decedents estates, and potential estate complications Forgery of a will literally somebody else signed your name. Improper execution, we've been involved in a number of cases in which people try and save money, they go on legal Zoom, they do their own will, and they have their children witness it. Completely invalid, okay? The witness to the will, two of them must be disinterested witnesses. They can't inherit under the terms of the document. Will construction, the terms are ambiguous. I leave my children, doesn't tell us which children, doesn't tell us how many children, and they've had multiple marriages, or a child out of wedlock. Did you want to provide for that child? It's not necessarily clear. Heirship disputes, who are the heirs of your, your family, of you? Sometimes, again, there's a confusion as to who that will be. Contested claims in Illinois, once the will is filed, the estate is opened, creditors have 6 months to file claims. Creditors are typically credit card companies, banks that have credit cards, the care facility, care providers, things of that nature. They must file their claims, which generally is an invoice, within 6 months from the time your post-death estate is open. Citations to recover. Somebody refuses to turn over property that you believe belongs to the estate. We issue a citation against them. They're subpoenaed to come to court and justify why they won't turn over the assets. Breach of fiduciary duty. The executor administrator has stolen money, or he refuses to distribute money, or refuses to account for their administration. They literally need to account dollar for dollar, where did the money go? And the last one is, again, accounting, or the executor's taken too much in the way of fees and tried to rip off the estate. This is an example of probate. It's a bad one. I'm confident in this room, everybody's heard of Elvis. So, you can see Elvis's estate started, it did pretty well, considering he died a long time ago. $10 million, he had debts of $4 million. The fees and the costs were $2 million. His taxes were $3 million. Look at the starting point and the ending point. Okay, pretty significant. With good planning, that wouldn't have been the situation. So, addressing the obvious, the elephant in the room. Typically, death is not a comfortable conversation. Nobody wants to talk about it. Nobody wants to believe they're going to die. Everybody thinks we're going to live forever, and nobody wants to plan. Just fundamentally, that's the issue. Get your planning done while you still have the ability to do it. Tell someone, your loved one, your executor, your lawyer. Some people leave their documents with their lawyers. Some people put them in safety deposit boxes. Today, safety deposit boxes don't seem so popular, but put it in a safe place and tell someone where it is. Don't just tell your spouse, because you're going to be in the car together and you're going to get back on the highway out here. God forbid you get killed and you only told your spouse where the documents were. Tell somebody else. Tell somebody named as executive. Tell somebody you trust. Even if you don't leave it with your lawyer, tell your lawyer it's under my bed in a box that's red, something of that nature. So people know where it is. You don't need to be wealthy to do estate planning. When you look at your current documents, does your will or trust match your wishes? Are your titles correct? Assets titled correctly? If you have a trust, have you funded it? And are you still comfortable with your agents under your power of attorney for healthcare or property? I don't have to tell you, relationships change, okay? Whether it's friendships or whether it's relative relationships, relationships change, particularly if somebody's out of town. I named my best friend, she lives in Dallas, Texas. Well, okay, if you go down to Dallas once a year or twice a year or celebrate Christmas together, maybe you want them to be your agent or your executive. But if you've lost touch with them, you gotta change it, okay? You gotta change it so you're comfortable and frankly, they're comfortable. So, that's it. Thank you very much. Have a good day. Thanks for coming out.